we'll start with this thing. So there is another topic from Constitution, which is like, one second, I'll just open the syllabus. Okay. So regarding this one is from Unit 4, okay, Public Service Commission, services under center and state, and constitutional protection to civil servants. So regarding that, we have a topic which covers a few sections, okay, so we will do that part today. So this entire thing, right, it is from Part 14 of the Constitution of India. So Part 14 is basically having two different chapters. All right, so if we look at the Bar Act. So if we look at the Bar Act, Part 14 is having basically two different chapters, and Chapter 2 talks about this Public Service Commission, right? Who all will be the members, where it will be appointed, how it will be done, and all that stuff is being mentioned there. And the first part is with regard to this constitutional protection which we have. So with regard to this topic, right, which we have in the syllabus, it is from Part 14 of the Constitution. So it basically has like two different chapters. All right, first chapter is with regard to services, right? And second chapter is with regard to this Public Service Commission. And this entire thing is basically given in that topic, all right, from the syllabus. So this concept of this Public Service Commission, right, and having like a all India basis exam and all that stuff, it basically started from this Charter Act of 1853. Like before having Constitution of India, right, we had something called as Government of India Act. Before that, we had some Charter Acts. Okay, so there are different years like Charter Act of this year, that year. There are a lot of different Charter Acts. So this Charter Act of 1853, it basically started with this concept of like Indian civil service for all, right? It basically opened this for everyone. Whoever is interested, they can appear for the exam and they can enter into this civil service thing. And the first exam, which was held in 1855, this year, it's like only for like a history part. You need not remember the year and stuff. You can simply mention that it started with Charter Act 1853, and then this concept was again introduced in Government of India Act as well. And then this continued even in Constitution of India. All right. So this concept basically started from there, and it also we have provisions under Constitution of India. So post-independence, Sardar Vallabhbhai Patel, he was amongst the top nationalist leaders who said that this provision should be like continued. We should include this in Constitution itself. So accordingly, the provision is being mentioned from Government of India Act 1935. We also have provisions with regard to it under Constitution of India. There were basically three commissions which gave some recommendations, which are also something that you can remember. If there is a question on Public Service Commission, you can mention these commissions as well. Okay, so first one is Kothari Committee, which had recommended that there will be this three-stage selection process. There will be one preliminary exam based on objective type questions with one optional paper and general studies paper. Then there will be one mains exam with subjective type question and 9 papers will be there. And then the final stage, which is like the interview part. Then there was another committee, which is Satish Chandra Committee of 1989, that recommended that we should introduce like an essay paper and more weightage should be given to this personality test or interview. Then there was another commission, Hota Commission of 2004, which recommended to introduce an aptitude paper in the preliminary exam. So basically you can remember names of these three committees, not the year, but you can remember name of these committees and say that these provisions, right, with regard to public service exam and the thing, there were recommendations of various committees, and accordingly these recommendations were being implemented as well. Okay, then if we look at the provisions which are being given under Constitution of India, it is Article 315, which basically mentions that there shall be a public service commission for union, which will be known as UPSC. Plus there will be also commissions for state, which will be known as State Public Service Commission. So whatever is the name of the state, then Public Service Commission. And these provisions are same like this High Court and all what we have, right? Ideally, there should be one commission for each state, but if needed, one Public Service Commission may also function for 2 or more states as well. At present, we have UPSC plus 29 state public service commissions we have. For union territories, we have Union Territory Civil Service. This is the link of their website if you want to see. So this is the provision which we have under Section 315, which makes provision with regard to UPSC as well as State Public Service Commission, right? There should be this commission established in order to take care of the all examination and all the stuff. Then appointment and term of office of members. So there will be these members and chairperson of these commissions, right? So with regard to them, there is provision that they will be appointed in case of union commission or joint commission by president. And in case it is with regard to state, they will be appointed by governor of the state. So these things, I guess, we also saw in terms of this powers and functions of governor and president, their powers with regard to appointment, right? There it will be important, but here they won't ask you question with regard to appointment and term of office of member. All right, but with regard to UPSC, it will be done by president, or in case of joint commission also, it will be done by president. With regard to state commission, it will be done by governor of the state. And they will hold office for a term of 6 years from date on which they enter their office or until he attains, in case of UPSC, 65 years, and in case of state commission or a joint commission, 62 years. So years are also different. Years you need not remember, this part you can remember. Okay, this part you can remember, and the same thing you would also apply with regard to powers of president as well as governor. Okay, administrative powers of president and governor, there you can mention this as well. Power to make regulations as to conditions of service of members and staff commission. So in case of union commission or joint commission, president, and in case of state commission, governor of the state may make regulations with regard to determination of number of members of the commission, their conditions of service, how many members are needed. Basically, this governor and president will oversee all the stuff, right? Their appointments and stuff, how many members are needed in order for them to perform their functions properly, etc. Make provisions with respect to number of members of the staff of the commission and their conditions of service. All that stuff will also be taken care of. Then functions of the commission, they will conduct examination for appointment to services of union and the state respectively. That is their like prime function, right? Appointment of candidates. They shall also have, it shall also be duty of UPSC if requested by 2 or more states so to do to assist those states in framing. Assist states in framing and operating schemes of joint recruitment for any service for which candidates possessing special qualification are required. This may also be done. Then on matter relating to methods of recruitment of civil services, they can also provide their inputs, like they can be consulted with regard to it. What principles to be followed with regard to appointments on all disciplinary matters affecting a person serving under Government of India or Government of State in a civil capacity, including memorials, petitions, etc. So with regard to disciplinary matters also, if some advice, some things are needed, those also will be taken care of. on any claim by or in respect of a person who is serving or has served under Government of India or Government of the state. So basically they will oversee and whatever is required, right? They will look after all that stuff. Claim for award of pension, they will see, right? So this is basically functions of Public Service Commission, and UPSC can also assist with regard to like 2 or more states if jointly they are conducting some exams and stuff, that also will be done by UPSC. There also UPSC may give their input. I'll just open the direct. So yeah, this is the provision basically, right? Part 14, services under union and state. First is this services. Here only protections are also being mentioned. Then here we have this interpretation clause that this part will apply with regard to the state, does not include the state of Jammu and Kashmir, because earlier the special thing was applicable, but now the special thing will no longer be applicable. Recruitment and condition of service of person serving union or a state. Subject to provisions of constitution, acts or of appropriate legislature may regulate the recruitment and condition of service of person appointed to public service, provided that it shall be competent for president or such person as he may think fit in case of service connection governor, as he may direct case of service in connection with the state, to make rules and regulations. So what is it? That to make rules and regulations regulating the recruitment, conditions of service of persons who are being so appointed to such service and post until provisions in this behalf is made under this act through appropriate legislation under this article, and any rules so made shall have effect subject to provisions of any act. So basically it says that regarding recruitment, conditions of service, etc., of people who are being appointed under UPSC or any state public service commission, right? So power is being given that you make clear rules and regulations by way of some legislations, right? So until and unless these legislations are being introduced, whenever needed, president or governor can introduce some rules or regulations in order to get this process done smoothly. They can introduce some rules and regulations. Those rules or regulations will be followed until and unless we have like a proper legislation, right? Proper statute. So once we have that statute, those will be followed subject to whatever provisions are being mentioned, right? So it basically says that we need to have like clear provisions with regard to recruitment, conditions of service, etc. And accordingly, legislations need to be introduced by appropriate body like parliament, or in case of state legislature will introduce those legislations. Accordingly, those provisions or procedures will be followed. So if you visit the website of like UPSC or any state public service commission, there you will see somewhere you will get one option like X or statute. There it will be mentioned what all legislations are being introduced and what all legislations apply to them, right? So there you will get to know legislations regarding conditions of service, recruitment, and all that stuff, where rules will be clearly mentioned. Okay, so this is regarding section 309, that proper or clear provisions has to be there. Like in case we saw, right, these committees are there which said that, okay, fine, there should be this 3-tier recruitment system. Someone said that, okay, we need to give more weightage to the interview round and all that stuff, right? Regarding those, clear rules need to be laid down, and accordingly those will be followed. So how those will be introduced? By way of some appropriate legislation only, right? Introduced by parliament or state legislature. That is section 309 of Constitution. Next one is section 310, which is tenure of office of person serving union or state. Except as expressly provided by Constitution, every person who is member of Defence Service, Civil Service of Union or All India Service or holds any post connected with defence or any civil post under Union holds office during pleasure of President. And every person who is member of Civil Service of a state holds civil post under the state holds office during pleasure of government. So this is called as this doctrine of pleasure. All right, you need to remember this section. It is article 310. All right, so what is doctrine of pleasure? We also got this in few other things, right? That this person will hold office during pleasure of the president, during pleasure of the governor, right? So that is nothing but this doctrine of pleasure, that this person will remain in his office only until pleasure of the president, right? Till president is satisfied that this person should be here, the person will basically stay there, right? So this concept is given under section 310 with regard to UPSC or other civil service exams, right? There it is mentioned. With regard to union, it will be during pleasure of president. With regard to state, it will be during pleasure of the governor. All right, so this provision is given under Article 310, Clause 1. Now, notwithstanding that a person holding a civil post under union or state holds office during pleasure of president or governor of the state, any conduct under which a person not being a member of defense or of All India Service or Civil Service Union is appointed under Constitution to hold such a post may, if president or governor as the case may be, deems it necessary in order to secure services of a person having special qualification, provide for payment to him of compensation if before expiration of his agreed period. Now, yes, we are saying first of all that this person will hold office during pleasure of the president or governor. But take for example, a person was being appointed that you will be holding this office for maybe 10 years, or you will be holding this office until you attain the age of 60 years, 45 years, whatever, right? There was one agreed term for which this person was being appointed. Now, if all of a sudden president or governor just says that, okay, fine, your job is done, you just go, right? That also would not be justified. Even though we are saying pleasure of president, doctrine of pleasure, it does not mean like whenever the person feels that person will be removed. That will not apply. When can we remove the person? Only with regard to like misconduct, right? Proven misconduct on the part of the person. Right? In that case, we can remove. Otherwise, if take for example, president feels that, okay, fine, this person is holding a certain position, but we have got someone better qualified who can serve this position, right? So we need to remove this existing person and appoint this better person for this position, right? In such cases, president or governor just cannot remove the person. They will have to pay necessary compensation, right? Payment to him of compensation. So the person must be compensated because he was removed from his position before this agreed period, right? Before agreed time frame, this person was removed, right? Or there might be certain cases where it may be felt that, okay, fine, this certain position or this designation which a person is holding, this designation or this department itself is of no use. We don't need this, right? That department itself is removed. In that case also, it can be like person can be removed from his office, but he will be paid adequate like compensation with regard to it, right? So this is nothing but doctrine of pleasure, that those persons hold office during pleasure of president or governor, but that does not mean those persons will be simply removed, but they can be removed only with regard to proven misconduct and stuff. Otherwise, if on pleasure of president or governor also they are removed, they will be paid adequate amount of compensation because they are removed before expiry of this time frame, right, for which they were being appointed. So this is with regard to this doctrine of pleasure, section article 310. Now, power of president or governor to dismiss civil servants is not a personal right. It does not mean that whenever they feel they can simply remove it, but it should only be exercised with the aid and advice of Council of Ministers. The Supreme Court of India has justified doctrine of pleasure on the ground of public policy, public interest, or public good, right? Might be in certain cases, if it is felt that this position itself is no more needed, it can be done. If it is felt that some better qualified person is there who may be appointed, in those cases it will be done, but it has to be done in a proper way, and accordingly the person should be removed. That is why we are discussing this part under protections given to civil servants, right? Constitutional protection. Constitution itself is guaranteeing this, that yes, you may be removed, but even in that case, you will be paid like adequate compensation regarding it. Then another provision that we have is section 311, which is with regard to dismissal, removal, or reduction in rank of persons employed in civil capacity, whether under center or state. No person who is a member of civil service of union or all India service or civil service of a state holds a civil post under union or state shall be dismissed or removed by an authority subordinate to which he is being appointed. Okay, so no person, right, who is holding any office under UPSC or under All India Civil Services or for state, right, whoever is holding those positions, they cannot be removed by a person or an authority which is subordinate in rank from who has appointed them. So who is appointing them? In case of UPSC, president. In case of state, it is governor. That means no one below president can remove them, right? That means tomorrow vice president cannot come and say that you are being removed from his office. It has to be president only who can remove with regard to UPSC. It has to be governor only who can remove with regard to this thing, right? With regard to states. Right. So first protection which we have is no person below the rank of appointing authority can remove those civil servants. Right. So that is first constitutional protection which is being guaranteed to them. Second one is no such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard for those charges. That means you simply cannot remove the person on a certain day, right? If you want to remove that person, you will have to properly frame the charges against him. If it was some proven misbehavior, some misconduct, whatever it was, you need to properly frame the charges. You need to inform the person regarding the charges, give him opportunity to defend himself. After a proper, complete inquiry only, you can remove the person. All right, if it is being satisfied. That is the second protection which is being given. Right, first one, no one below the rank of appointing authority can remove. Second one, even if you are removing, you cannot just simply remove the person. It has to be after proper inquiry and all that stuff, right? And giving reasonable opportunity of being heard, informing the charges and all that stuff. So in these cases, usually this show cause notice is served to the person, right? That these are the things which, like we have maybe came to know. So give us reasons why you should not be removed from your position. Right? Show us cause as to why we should not like take an action against you. So those stuff accordingly will be done. Now here we have like another provision provided that where it is proposed after such inquiry to impose upon him such penalty, any such penalty may be imposed on the basis of evidence during such inquiry, and it shall be necessary to give such person an opportunity of making representation on the penalty proposed. So in case it is being figured out, they want to impose some penalty and stuff also, that may be done. Provided further that this clause shall not apply where the person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on criminal charges. Okay, so if there are some criminal charges and all that stuff in regular court or cases going on, in such cases, it may not be necessary, right? So where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, right? So he was being convicted in some criminal case, and because of that reason only the person was reduced in rank, or might be he was dismissed or removed from his office, right? So in such cases, it is not necessary that you again conduct some inquiry and other stuff, because regular court is anyways doing it. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by the authority in writing, it is not reasonably practicable to hold such inquiry. Okay, so next is where the authority. So where you got disconnected, by the way?
I think before point also I couldn't hear.
Like this one?
Penalty one I heard.
Okay, penalty you heard. All right. Okay, so provided further that this clause shall not apply. So basically this clause, right, which says that you conduct an inquiry, you give him fair chance to defend himself, frame charges, inform him and all that stuff, this may not apply in some cases. Where it will not apply? In case there are some criminal charges wherein the person is being convicted, right? In a regular court, there were some criminal charges, the person is convicted. Based on that conviction, person was removed from his office, dismissed from his office, or he was reduced in rank. In such cases, again, you don't need to conduct an inquiry, right? Because it's already because of that criminal case only you are doing. So in that case, this provision would not apply. Secondly, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded in writing, it is not reasonably practicable to hold such inquiry. Because these people are like in higher ranks, right? They will have so much of like confidential information regarding government also, right? Those things also they will deal with. So sometimes, right, it might not be reasonable to conduct such an inquiry. Otherwise, like information will be available in public domain, right? So there may be some cases wherein, you know, like the person was dealing with some very confidential matters. In case some other people are allowed to inquire into it, it might be, you know, like it might be difficult for the government, right? So in case it is felt that it's not reasonable to inquire, make, you know, like conduct such an inquiry, that also like authority is given to this authority, right? That power is given to that authority. They can, for reasons recorded in writing, they can say that because of this reason, it is not practicable to like conduct this inquiry and do it, right? So there might be some exceptional cases where that thing is allowed, just because it might be some confidential information wherein just inquiry cannot be done, right? Or it would not be reasonable. So accordingly, it can also be allowed. Where the president or governor, as the case may be, is satisfied that in the interest of security of the state, it is like a better decision not to conduct the inquiry, right? So sometimes it may be only because of security reasons, like security related, some confidential information might be leaked in case inquiry is done. In such cases also, it may be said that president or governor may say that no, it is not possible. Or for any other reasons also, the authority itself is given the power that they can also record reasons in writing and say that because of this reason, it will not be possible to conduct the inquiry, and accordingly it would be done, right? So otherwise, general rule is that you conduct an inquiry, frame the charges, inform the person, give him enough chances to defend and stuff. After that only you remove. But there may be exceptional cases also based on their, like the kind of thing that they are dealing with. There might be some exceptional cases as well. Right. So first one is with regard to this, that they will hold office, but they cannot be removed or dismissed by any authority subordinate in rank. Second one is, in case they are removed or dismissed, there has to be like a proper inquiry. Now, third one, if in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such an inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. So whatever decision basically this authority is taking, right? Authority is given like power, right? If in respect of any such person as mentioned above, a question arises whether it is reasonably practicable to hold such an inquiry with regard to this clause 2, the decision whatever is taken by the authority will be final, right? Authority empowered to dismiss or remove the person will be considered as final, because in some cases it might not be practically possible to conduct the inquiry. So in such cases, authority is basically given the power to take a decision regarding it after mentioning the reasons in writing. So there was this case in the state of Bihar versus Abdul Majid. It was held that power of president or governor to dismiss public servants is not a personal right of theirs. It should only be exercised with aid and advice of Council of Ministers. And accordingly, they will be doing it, right? So it, even if it mentions like pleasure of president, it does not mean simply they will do whatever is the rules and regulations that will basically apply with regard to them. Removed by any authority subordinate to who has appointed them. After an inquiry only, they can be removed. Yeah. So these are basically the protections which are given to civil servants. Then doctrine of pleasure, and also the general provisions with regard to having like a public service commission, right? So this highlighted part is basically important. Otherwise, there may be like too many sections. All the sections are not important. Yeah, so this is from this one, your unit 4, Public Service Commission, services under center and state, constitutional protections with regard to civil service. Is this part clear? So I've just added the sections and stuff. I will like write it like note sort of a form, and we'll share the document with you. Okay, these are like only sections that I have added basically. So there are these 2 things remaining from unit 4. We will do that part. So can we do then like tomorrow 7 to something?
I'm okay tomorrow morning.
Like morning, I'm asking.
Yes, tomorrow morning I'm okay to attend.
Okay. So like morning we can do one class, and then like this time we can do.
Okay.
All right, fine then. So 7 to some 7:45 we will complete some 1 or 2 topics. Okay.
Okay.
Yeah. Okay, fine then. We'll end this class here. Okay.
Yeah, sure. Thanks for that. Bye.
Thank you.